Hey guys, I'm back with the another lesson, okay, where we are discussing solution for IPR and cyber law paper 2016. Okay, so in last lecture we already discussed question 1, and now in this lecture we are going to start our discussion with the question 1 sub question B. Okay, now what this question states that explain the basic steps for of applying for patent. So this question from paper 2016 IPR and cyber law, okay, B.Sc Sem 6 Mumbai University. So let's just start discussing this particular answer for this question. So I've already provided steps, okay, how to file an application. So as you can see, file an application in IPO. IPO stands for Indian Patent Office. Okay, IPO stands for Indian Patent Office. So basically we have 4 IPO offices in India, one in Mumbai, Delhi, Chennai, Kolkata. So Mumbai basically for west part of India, Delhi for south part, Kolkata for east part, and Chennai for south part. So this way India basically divided in 4 parts, and we have total 4 IPO offices. So how we basically follow the steps? First, we need to go and file an application. If I belong to Mumbai, or if I belong to region, okay, like in Maharashtra or somewhere in Goa, then I need to file an application in which IPO? Mumbai IPO. Okay, so first we need to go and file an application. Application is same like you guys make synopsis, right? Synopsis for your project. So the same way we also need to file an application like project synopsis only, where we are going to add all the details like how we basically came up with that idea, and for which field, okay, or for which type of business application that idea might be, we can utilize the same idea, and research and diagrams, and so in briefly you have to describe everything in that application, plus you have to pay some application fee. And once we are done with that application, and one more thing, while you go for to file an application, first thing, there is always an eligibility criteria. Okay, your idea must be somewhat like which is something unique. Okay, you must have studied about a patent topic, like what is patent, novel, unique, and idea which is not in which is not yet used in a public domain. Those type of ideas only we can go and file for a patent. Okay, so we have to first go and file an application in IPO. Once we file this, okay, now as we know, it takes a lot. Okay, it is very tedious task, you can see. So if you want this process to be faster enough, okay, if we need to launch a new product like Samsung or iPhone, they want to launch a new product, okay, like in next 6 months or in the next 1 year, then they need to go for early publication request. Remember, go for early publication request. If we file an application for just a normal patent way only, then it takes like 1-2 years actually to get our idea certified or get our idea patented. Okay, so one way is file an early publication. Filing an early publication request is an optional. Remember, it is an optional. Okay, it is not compulsory. This request is filed to have your patent application published early. As I said, yes, if you want to publish. Now what this publication means? Okay, once we go and file an application, so before processing that application, okay, to get patented, what they do is they will publish, okay, the same application or the same request in intellectual property journal. Okay, so if someone claims that this idea belongs to them, then you cannot carry forward with the same. Then you have to go and file a case in appellate tribunal, where one panel is going to take decision, okay, after listening statements, or after listening all the claims from both the parties. Okay, one who claiming this idea belongs to them, and one who claims that you are misusing their idea. Okay, so two party claims each other's rights on the same idea, and that time your patent application goes in a controversy. So this publication, okay, application, one advertise comes in a intellectual property manual or a journal. So that is very important. So if we go in a proper normal procedure, then it takes like 12 months, okay, maximum 12 months to publish your this application in intellectual property journal. If you go for early publication, then within a month they are going to publish the same. Next step is, if you file an early publication request, then your patent application will be published by IPO. As I said, within 1 week, okay, maximum it goes up to 1 month, okay, but within 1 week it should be done. Then next step is, if the early publication request is not filed, then it takes like maximum it goes up to 18 months. Okay, so maximum time period, it might possible your application might be published before 18 months, like within 6 months or 8 months. Okay, this is maximum duration. Next step is file a request for examination. Now it is very important, examination. Okay, like if you go and submit your synopsis to your coordinator or HOD, what they're going to do, they are going to examine that particular project, whether that particular project is eligible or not, whether the technology which you are going to use is enough as per the TY/B.Sc level or not, okay, and many other things. So the same way they are going to examine your idea, like we are going to use this idea in a public domain, so it should not happen that your idea might hamper or might affect environment or a people in any XYZ way. So we should have proper examination. Okay, this request can be filed within 48 months from priority date. Okay, priority date means date of registration. Okay, note that IPO will not examine your patent application unless this request is filed. So we have to file particular request for examination. Hence, if you wish to expedite patent process, early filing of examination request is advised. So if we need to make this process more faster, then go for examination as early as possible. Then next step is, once the IPO receives your request for examination, IPO puts your application in a queue. Obviously, there are thousands and thousands of patent application comes every year. Okay, if you just check the statistics for 2016 years, more than around 3,000 or 4,000 applications. Okay, people filed an application, and out of this, approx some 200 or 300 application only. 300 or 200 or 300 people got patent certified. Okay, their idea certified as, or their idea patented. Okay, now next step is, once IPO receives your request for examination, IPO puts your application in a queue. Subsequent, your patent application will be examined. Okay, so they are going to examine properly that this idea belongs to you only, this is your original creation, and at the same time how we can benefit we can take the benefit out of the same idea, whether it is actually going to benefit in industry or somewhere or not. Okay, all these things. In light of examination, if the IPO is the opinion that your patent application satisfy all requirement of patentability. What are the requirements? Your idea should be novel. Yes, one thing, your idea should not be some type of idea which might hamper or which might affect environment or people or their health or any XYZ thing. Okay, and it should not be some idea which is already known in a public domain, like if we have many laws defined by Newton or Einstein, so we cannot just make a combination of 2-3 laws and we create our some own idea or our own law, okay, based on ideas which is already present. Okay, so that is what it is states here. Then next is, on the other hand, after examining your application, if the IPO, if the opinion, requirement, patentability are not met, then first examination report is issued. Remember, if they find that your patent application or your idea is not up to the mark, okay, then they goes for first examination report, where they might find some loopholes or some drawbacks okay, which they will tell you to overcome those drawback or loopholes. And once you are done with that, then they can again go they can put this application in a process. Okay, so, and if you are done with this, then goes for registration. Or if you fail to prove eligibility of your idea, then your patent application going to be rejected. Next step is you will have to respond to first examination. FER means first examination report, and you will get 12 months to recover those loopholes. Okay, then however it is advisable respond as early as possible. By responding early, you provide an opportunity, है ना? So everything the same. Then next step, in light of communication with IPO, the IPO can either grant a patent or reject a patent. So let's just study the same thing. As I said, I have provided this flowchart here. So establish prior patent date, file application, the same points which we discussed. Okay, so as you can see, has an early publication request been filed? If yes, then what? If no, then go with the regular flow. Okay, then is the patent application is in order or something? Then if is the patent application in order for grant? If yes, then directly grant a patent and your idea is certified. If no, then it goes for examination report, and you will get 12 months. As you can see, you will get you will have 12 months to respond, okay, to first examination report. And within that 12 months, if your response is satisfactory to IPO, then they will grant a patent, else they are going to reject a patent. I hope it is clear. Yes, okay. So in next lecture we'll discuss question number 3. Okay, question 1 sub question 3. Thank you.